Some U.S. judges are now using the Laken Riley Act in the opposite way that it was intended for, to release immigrants from ICE custody. The law gives immigration agents the authority to take illegal immigrants into custody if they have been arrested for or convicted of a violent crime. Legislation is named after a college student from Georgia who was killed by a man in the country illegally. Some judges are using it to order the release of immigrants in ICE custody who have not been arrested. Chief Legal Analyst Rhodes joins us now to talk a little bit about it. How are the judges interpreting this law?
Brian, this is a great question, a unique approach, but this happens all the time. The best example I can do and think about this is probably with affirmative action, not a criminal matter, but you had all these cases with affirmative action that were coming through to allow African Americans to get into schools. And then what happens in the late 90s, early 2000s, on the reverse side, hey, you are now discriminating against the very folks that you were trying to stop from letting you into the school. And so you all saw these reverse discrimination cases. I think that's the same type of logic that these judges are using. But before I go there, let me tell you a couple things. First of all, we have to look at when folks come to this country, when is it a crime and when is it not a crime? I think that's the first thing, because everyone's like, hey, you're here illegally, it must be a crime. To be in the country right now illegally is not a criminal offense, it's a civil offense. But now if you're at the border, you're attempting to get into the border and you've done something to, evade inspection, yes, that's a misdemeanor. If you've been deported and brought back, now you come back in, yes, that's a felony. But just simply being here, your presence, not a criminal offense. So when they're talking about this act, it was implemented earlier this year, it's not saying your presence here is a criminal act, it's that you've committed some other crime. And because you've committed or been convicted of some other crime, now we're going to convict you. So what the judge is saying, well, if we had to pass a law to give ICE the ability to take this person and now to put them through the deportation process, maybe they don't have broad authority. Because we had to make law that they have the ability to do that for folks that are committed of a crime and or charged. If you're not committing a crime and you haven't been charged, that means they don't have authority. And that's a novel approach. And I don't think it's, sua sponte. I don't think the judges are thinking of this on their own, but this is something that's being brought and presented by a petitioner, and now the judges are allowing this to be a thoughtful argument.
Well, what needs to happen going forward and how to implement this law?
Well, I mean, someone would have to say, hey, first I'm going to request a hearing, I'm going to challenge my deportation, and in that process I'm going to say, I've never been convicted of a crime. I'm not charged with a crime. You got the wrong person. I mean, you're going to make any of these allegations that say that they can't remove you. And if they can't point to a crime, if the judge is going to have a show cause hearing, and in that hearing, they're going to say, what are they charged with? What is the crime that you're saying they've committed? And if it's something other than just being in this country, the order is going to have to be that you release them. Now, on the flip side, what happens normally with this is when you find these loopholes and ways around laws, Congress acts. Congress will say, yeah, it moves at, snail's pace. But it does act, and they can say, look, we didn't intend this to happen. We didn't anticipate that we would allow now folks that haven't got a crime or haven't been charged or committed with a crime, that they can also not be taken through this deportation process. But I think that's going to be a lot harder for Congress to pass, because it opens up the door for basically anybody.
Yeah, and the law was passed quickly in response to what happened with Laken Riley, too. So now we'll have to see how that does get implemented going forward.
Any patch, any fix won't be quick, I can tell you that. But I think these are novel, one-off approaches to say, look, you guys have charged and attempted to put people through this process that you don't even have authorization to do. And that, again, I tip my hat to any of the attorneys that have made the argument and to the judges that have at least been able to listen to the argument.
All right, we'll leave it there. Chief Legal Analyst Rhodes, thanks.
Queen City News Plus. Just search Queen City News on your smart TV's app store.